Hello students, this is week 3 of family law. I am Advocate Nachtigal. We are currently still busy with the validity requirements for the conclusion of a valid union. Can you still remember what these validity requirements are? Last week we discussed the first requirement, namely consensus. This week we will consider the second and third requirements, which is capacity to act and lawfulness. In this presentation, I will, however, only focus on the requirement of capacity to act. Please watch the second presentation of this week for a discussion of the requirement of lawfulness. In relation to the requirements of capacity to act, there are a number of questions which you will have to be able to answer at the end of this week and after having worked through this presentation as well as the prescribed material. Firstly, what does capacity to act mean? Secondly, what are the factors that can influence a person's capacity to act? Thirdly, what is the minimum marriageable age for each of the recognized unions in South Africa? Fourthly, which consent requirements apply to the marriage of a minor where it is allowed? And lastly, what is the effect on the validity of the marriage if consent is not obtained? From your study of the law of persons, you should already be familiar with the concept capacity to act. It refers to the ability of a person to understand the legal nature and the legal consequences of legal acts. Since the conclusion of a union is a legal act, a person must be able to understand the legal nature and consequences of the conclusion of a union. As with consensus, there are also a number of factors that can affect or exclude a person's capacity to act. Two important ones are mental illness and age. The effect of mental illness on a person's capacity to act was dealt with comprehensively in the law of persons. You may perhaps remember that a person who is certified as mentally ill is treated differently from a person who is not certified as mentally ill, particularly in relation to that person's onus of proof. If this part of the work is hazy to you at this moment, please take the time to work through this part of the Law of Persons course again, because it will not be repeated here. From the principles in the Law of Persons, you should be able to deduce exactly when a mentally ill person can be considered to have concluded a valid union and when he or she cannot. There will also be a discussion board question on this particular issue. Where the second factor of age is concerned, you would have also learnt in the Law of Persons that a distinction can be made between a person who has no capacity to act, a person who has a limited capacity to act, and a person who has full capacity to act. Can you remember these age limits? For purposes of investigating the effect of a person's age on the conclusion of a valid union, a distinction must be made between the conclusion of a civil marriage and a customary marriage on the one hand, and the conclusion of a civil union on the other hand. Civil unions fall into a separate category for this validity requirement, because from the definition of a civil union, which we also looked at in week 2, it is clear that the Civil Union Act prohibits the conclusion of a civil union by a person below the age of 18 without exception. The Marriage Act and the RCMA, on the other hand, allow minors or children under the age of 18 to conclude marriages under these acts. More on the possible discrimination which arises in this case will be said later in this presentation, but for now I will discuss the provisions pertaining to the age requirements that apply to marriages under the Marriage Act and the RCMA. Neither the Marriage Act nor the RCMA prescribes the minimum marriageable age for marriage in terms of these acts. The only indication we have in South Africa of what the minimum age for marriage is the common law. In terms of the common law, the minimum age for marriage as envisaged in the Marriage Act depends on a person's sex. Girls may marry from the age of 12, but boys may only marry from the age of 14. In the case of State versus Jazile, which was also mentioned last week when we were dealing with consensus in the context of customary marriages, Professor Ronald Nhlapo, an expert on customary law, testified that in customary law, a woman is considered to be of marriageable age when she is able to bear children. This can be taken as a confirmation that the minimum age in terms of the common law likely also applies to customary marriages. However, nothing was said about the minimum marriageable age of boys. This immediately raises the question of whether the differentiation between the sexes, as far as the minimum age is concerned, amounts to unfair discrimination. Because marriage is historically linked to procreation, and procreation is linked to the age of puberty, which is generally deemed to commence for girls at the age of 12 and for boys at the age of 14, the differentiation in this particular case is not considered to be unfair. That means it can be said there is a good or a justifiable reason for the differentiation. Whether the age of 12 can, in fact, still be considered to be the age of puberty for girls is a different issue altogether, and new scientific evidence will have to be considered to see if this is still the case. Up to now, we have actually answered the first 3 questions which were posed at the beginning of this presentation in relation to capacity to act. After having established that a child may conclude a civil marriage or a customary marriage, it is important to return to the issue of limited capacity to act. Because a child in this age category requires assistance or consent to perform legal acts, it should come as no surprise that children also need consent to conclude a valid union. We will now continue to consider this requirement of consent. But at the outset, it's important to realize that the requirement of consent is not meant to be a hurdle or a hindrance for children who wish to marry, although it may be perceived to be so by them. These consent requirements are deemed necessary to protect the child against his or her own lack of maturity when it comes to making decisions which are as significant as whether to conclude a union or not. There are 4 different consent requirements which can apply in different situations. A situation may require parental consent, the consent of the Minister of Home Affairs, the consent of the presiding officer of the Children's Court, or even the consent of the High Court. In the event that a child wants to marry, all the child's guardians must consent, and a child's guardians are usually the child's parents. But there may be instances where a third party has been appointed as a guardian, for instance, where a child has been orphaned. It's also important to note that all parents do not necessarily have guardianship over the child, for instance, where a court has granted an order for sole guardianship to one parent after divorce. The concept of guardianship is very important, but it will be discussed in more detail in Theme 3 when dealing with the law of parent and child. For now, it's sufficient for you to know that guardianship is different from care, in that guardianship relates to the parent's responsibility to assist a child in legal matters, such as the conclusion of contracts, which includes the conclusion of marriages. In conclusion on this first consent requirement, every parent vested with guardianship and any other person to whom guardianship has been assigned must consent to the child's marriage. If the marriage is concluded without the required consent from one or more of the guardians, the marriage is voidable. By now, you should have an understanding of what it means to say that the marriage is voidable. It means a valid marriage comes into existence, but an application may be brought to court to annul the marriage or to set the marriage aside. That means the same thing, annulment and setting the marriage aside. Who can bring this application where parental consent was not obtained? According to the Marriage Act, either the parent or guardian or the child him or herself may apply for annulment of the marriage, but only within very strict time limits. The parents or guardians must apply before the child becomes a major and within 6 weeks of becoming aware of the marriage that was concluded without their consent. So both of these requirements must be met. What this means is that if the parents find out about the marriage only 4 weeks before the child turns 18, the parents will only have 4 weeks left to apply for annulment of the marriage. The child, him or herself, can apply for annulment any time before reaching the age of majority or within 3 months after reaching the age of majority. So this means that the child has an additional 3-month window period to have a marriage annulled which was concluded before he or she reached the age of majority. An interesting question that can arise in this context is, how would you deal with a child who approaches you to help her to have her marriage annulled 6 months after turning 18? Would you simply turn that child away because of the expiry of the time limit in terms of the Marriage Act? Or would you be able to assist that child with perhaps the help of the Constitution? This is also an issue which will be on the discussion board this week, and I look forward to your arguments and your participation in this regard. In addition to parental consent, the Marriage Act and the RCMA add another layer of protection before a minor can conclude a marriage. According to the Marriage Act, girls under the age of 15 and boys under the age of 18 must also obtain the consent of the Minister of Home Affairs. It's important to note here that while the absence of parental consent would render the marriage voidable, the absence of ministerial consent will render the marriage void. The practical implication of this is, should, for instance, a girl of 13 years conclude a marriage without the consent of the minister, the marriage will be void even if she obtained the consent of her parents. You should also note that it is possible for a child to get the consent of the minister after the marriage has been concluded. This is provided for in Section 6 of the Marriage Act. If the minister gives consent after the fact, this will make the marriage valid with retrospective effect, as if the consent of the minister had been obtained from the start. This is what we call ratification of the union. Although Section 3 of the RCMA also requires the consent of the Minister of Home Affairs when a child wants to conclude a customary marriage, this requirement differs from the one found in the Marriage Act. According to the RCMA, all boys and girls under the age of 18 must, in addition to parental consent, also obtain ministerial consent. This would mean that while a girl of 15 years or older would not need the consent of the minister to conclude a civil marriage, that same girl would need the consent of the minister to conclude a customary marriage. This differentiation is hard to justify because it is based purely on the type of marriage that the minor wishes to conclude. This differentiation could also easily be challenged on the basis that it unfairly discriminates against girls on the ground of age and perhaps even their culture. Boys, on the other hand, are not affected because all boys under the Marriage Act and RCMA need to obtain the consent of the minister. Where a child does not have parents, because the child has, for instance, been orphaned, or the child has a parent, but the consent of that parent cannot be obtained for a very good reason, such as the fact that the parent is in a coma or is missing and cannot be traced, the presiding officer of the Children's Court must give consent for the marriage of the child. The Children's Court is a specialized magistrates court that hears matters in relation to the adoption, children in need of care and protection, matters relating to care and contact of children, and so forth. The Children's Court derives its power from the Children's Act, and if you want to know more about the type of orders that a Children's Court can make, you are welcome to have a look at Section 46 of the Children's Act. It should be noted also that the consent of the presiding officer of the Children's Court is replacement consent. That is consent in the place of the parents or guardians. So should the consent of the presiding officer of the Children's Court not be obtained where it is required, it will also render the marriage voidable. But very, very important, the consent of the presiding officer of the Children's Court cannot be obtained where the parents of the child refuse to consent to the child's marriage. Where the parents or even just one of them refuses to consent, the child needs to approach the High Court for consent. We already saw from the definition of a civil union that a child is prohibited from concluding a civil union in terms of the Civil Union Act. We can also note here that this position where a child who wants to conclude a union with a person of the same sex and is not allowed to do so could be challenged as amounting to unfair discrimination based not only on age but also sexual orientation. Although the Civil Union Act can be criticized for being out of step with both the Marriage Act and the RCMA, the Civil Union Act may for other reasons be argued to be the only act that upholds the best interests of children in terms of Section 28(2) of the Constitution. It is a well-known fact that allowing children, and especially girls, to get married violates their most basic human rights. I've posted 2 videos for you to gain a better insight into the many negative outcomes for children who enter into marriage. If child marriages are seen as violating the constitutional rights of children, especially girls, then the Civil Union Act could be seen as the only constitutionally acceptable act governing unions insofar as this act prohibits the unions between children. I would fail in my duty if I did not alert you to the international movement in support of the eradication of child marriages. Here you will find 2 of the main websites which deal with the issue of child marriages, the UNICEF website and Girls Not Brides. I strongly encourage you to go onto these websites and to read the content there in order to broaden your own knowledge and understanding regarding the specific topic. While child marriage is a global problem, I want to bring the focus back to Africa. Here we have the African Charter on the Rights and Welfare of the Child. This charter was adopted by many African countries, including South Africa, to focus on the needs and protection of African children. The charter is a regional international instrument and it supplements the more well-known United Nations Convention on the Rights of the Child. According to Article 21(2) of the charter, child marriage and the betrothal of girls and boys shall be prohibited, and effective action including legislation shall be taken to specify the minimum age of marriage to be 18 years and to make registration of all marriages in an official registry compulsory. There are a lot of current efforts and programs toward the elimination of child marriage. If you want to trace the initiatives that have been taken by African countries to curb and even abolish the practice of child marriage, I urge you strongly to look at the websites previously provided. You are also required to read this article by Mwambene to see how Zimbabwe, Malawi and South Africa have responded to child marriage, and to see how these 3 African countries are faring with their obligations in terms of the African Charter. So far, only 6 countries in East and Southern Africa have set the age of consent to marriage at 18 years without exception. These countries are Eritrea, Kenya, Mozambique, Rwanda, South Sudan and Uganda. We should, however, be cognizant of the fact that even if there are official laws, these do not guarantee that there will be no child marriages, as customary law and religious law continue to permit child marriage. In the presentation on consensus, I mentioned an investigation by the South African Law Reform Commission into the practice of ukutwala. This investigation also included an investigation into the practice of child marriage in South Africa. Again, I encourage you to read the discussion paper, which is available under your additional material, in order for yourself to broaden your knowledge on this specific topic, even though it's not part of your prescribed material. You should also take note of the fact that there is a draft bill called the Prohibition of Forced Marriages and Child Marriages Bill. In this bill, the concept of child marriage is defined, as well as the concept of forced marriage. This bill also proposes the criminalization of both child and forced marriages. Even even though Section 4 of the proposed bill will make it an offence to conclude a union with a child, the provision then adds the qualification unless he or she complies with the provisions of the Recognition of Customary Marriage Act, the Marriage Act, and the Children's Act. The effect of this qualification would make marriages by children concluded with the necessary consent in terms of the Marriage Act and the RCMA valid. This provision would therefore not change the current position regarding child marriage in South Africa at all, because it will continue to allow children to get married. These proposed provisions are not yet enacted and it's not yet part of our law, but given the extent of the objections to, in particular, this provision, it will probably never become law. The Children's Act, which is also mentioned here, does not set the minimum age for marriage. The provision just refers to the minimum age set by law without indicating to which law is being referred to. If it's understood to be a reference to the common law, then the minimum age will remain set at 12 for girls and 14 for boys. In this way, again, it will not change or eradicate the possibility of child marriage in South Africa. As mentioned, the provisions proposed by the Law Commission have been severely criticised, and it can be summarised in the following 3 points in as far as it relates to the issue of child marriage. Firstly, the bill does not clearly set the minimum marriageable age at 18 without exceptions. Secondly, it does not repeal the Marriage Act and the RCMA that allows for children under the age of 18 to get married. Thirdly, it does not amend the Children's Act provisions that are vague in relation to the minimum marriageable age. In conclusion of the topic of capacity to act, this table was drafted by Professor Lowe to give you some indication of the chaotic and confusing age limits set for different purposes of the law. You will be confronted with the age limits in the right-hand side column in other modules such as the law of delict and criminal law. This table does not even give a complete reflection of the state, since it doesn't contain other types of age requirements, such as those for consent to medical procedures and abortion.